minority probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? That we are mocked. People don't believe us anymore. This court has the power to impinge upon the authority of the speaker to take a decision on the above issues. Well, that's an argument, well, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant.
Mr. Sibbal, the only problem is, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue, the government has to continue. It's basically reduced to a complete minority probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaz. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaz? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister. You become a chief minister. Use the governor's office for that. Your Lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, so
now we go on to Shivraj Singh.
Then Mala Shivraj. Just government determined by the convening of a floor test are premised on the constitutional principle that neither the court nor the governor has any right to impinge on the speaker's power to decide on the issue of disqualification. This court cannot say that you cannot decide or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the court. It is straight law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. Well, that's now 5 judges have said that. Therefore, Malaz, that order on the 27th put us in a situation, Malaz, where the elected government was toppled. Neither the governor nor for that matter the court can entrench upon the power of the speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. And when Bomai was decided and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your lordship. That what Bomai said was the acts that have happened in between can be validated by the court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the Chief Minister Mullahs by setting aside the order of the governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your lordships decide one way or the other. Anyway, Mullahs, I'll just quickly now. Then Mullahs, kindly come to 46. S.R. Bomai and Union, the court, while considering the legality of a presidential proclamation under 356 that has been subsequently approved by both houses of parliament, held that an invalid proclamation would nevertheless have to be set aside. So this argument, Mullah, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant. Bomai says so. Held that the governor get this power from. Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the election commission. The leader is as communicated to the election commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mullahs. Petitioners have shown that the undisputed facts of the respondents, namely so-and-so, passing a parallel resolutions. Mullahs, I will let Dr. Singhvi actually deal with this because originally also he had dealt with it. So let's sort of... Then Mullahs, C1, now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting, Mullahs, from the transcript, how useful this transcript is, Mullahs. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the Shiv Sena, represent the rival faction. Now he's accepting it. Representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he is saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself, what political party? So I'm quoting only from the transcript. And has now been recognized as a political party is in question in this matter. Then, Mullahs, I've said the contentions of the respondents never claim that they are a faction of the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available, Mullahs. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. Well, I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3 at page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities, and to prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in Shiv Sena, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, "We have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party." What's the basis of this submission? And I still say I am the original political party. So first he says I'm a faction, now he says I am the original political party, because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says my faction is the political party. Thus, in substance, the respondents contend that the faction representing a majority of the legislature party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. It is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of People's Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde Group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it.